las autoridades para recoger sus pertenencias.
Good luck, sir.
Buena suerte, señor.
Thank you, Judge.
All right, thank you. Anything else for Osceola this morning?
That's it, Your Honor.
Have a nice day. If I could have the interpreter stay on the line, we have some Orange County cases.
Yes.
Oh, I have to disconnect? I'm sorry, I think I have to disconnect and then reconnect with you.
Okay.
Sorry about that.
Good morning, Your Honor.
Good morning, sorry about that.
No, don't worry.
Could you please connect with the headset?
Yes, please allow me to connect.
Sir, please tell me your name.
Sí. Joshua Pagan. Joshua Pagan.
Joshua Pagan.
21 MM 418 AW. You're here charged with battery domestic violence. There is probable cause in this case. I'll appoint an attorney to represent you. I'm going to place you on pretrial release and require that you post a monetary bond of $250. With special conditions, you're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. You must also comply with any plans set in place by DCF. You can't have any unsupervised contact with any minor child under the age of 18. Good luck, sir.
Your Honor, I'm sorry.
Yes.
She has a victim, it's just they just showed up.
All right, hold on one moment. Can we put the headset back on him? Ma'am, do you wish to testify this morning? You have to speak up.
Yes,
Do you need the interpreter?
I don't. I don't.
Okay, please raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
It is.
Thank you. Please state your name for the record.
Cindy Araujo Donado.
I'm sorry, tell me your name one more time.
Cindy Araujo Donado.
Does the state wish to inquire?
Yes, Your Honor. Why are you here today?
I'm sorry.
Why are you here today?
Why?
Yes.
Because I had an incident with my husband at home,
Who's your husband?
Joshua.
What, can you describe the
Okay.
incident?
Yeah. So I was texting with a friend. It was late night, and he got into the room, and he saw me, so he wanted to check my phone, and I said no, it's my privacy that I don't want to share with you. So he wanted to take my phone away from me, and we started fighting about it. And so we were like, discussing, like arguing, and
That's fine. That's fine. Thank you. No further questions, Your Honor.
Do you wish to have contact with him?
well, we have a baby, so I don't know how it will work. At this point, my relationship is done, so I don't want to be with him, but we have a baby, so I don't know. I don't really know what to do. And I know if I don't do like a non-contact, he's gonna be able to go and to my place and try to be with me, and he's gonna keep calling me. So that's what I don't really know what to do. He's
All right, at
not-
this time, I've ordered that he's not allowed to have any contact with you and that he can't live with you. So I'm going to stay that order. Good luck, sir. Thank you, ma'am, for coming. Good luck.
Thank you.
Sir, please tell me your name.
Soy Eduardo Aldegundo Ruiz Gómez.
José Eduardo Aldegundo Ruiz Gómez.
21 CF 8164, you're here charged with possession of fentanyl and possession of cocaine. I'm going to appoint an attorney to represent you. Mr. Brands, did you wish to be heard?
Your Honor, I believe the arrest, I just wanted confirmation of the charge. The arrest affidavit states a charge of controlled substance without prescription, and then the current PTR sheet says possession of fentanyl. Can I have a confirmation that it is a fentanyl charge as opposed to a controlled substance charge?
It is. I think it's the same charge, but it's specifically fentanyl.
All right, thank you.
There is probable cause. And in 21 CT 629, you're charged with operating a motor vehicle without a valid driver's license. There's also probable cause for that. I'll appoint an attorney to represent you. Your bond will be $150 on the no valid driver's license, $1,000 on count 1 on the CF case, and $150 on count 2. You understand that you can't drive without a valid Florida license?
Sí, entiendo.
Yes, I understand.
You can't possess or consume any controlled substance without a valid prescription, and you can't have contact with any known drug dealers. Do you understand? No,
I understand.
just the drug case. All right, good luck, sir. I believe that's all we have for the Spanish interpreter. We have one more? No, we have one more. All right, sir, please tell me your name.
Sergio Trujillo Santiago. Sergio Trujillo Santiago.
Sergio Trujillo Santiago.
21 CF 8116. We reset this one from yesterday. Does the state have any additional information they'd like to present?
Yes, Your Honor. May I approach?
Yes, please.
Sí.
Thank you. I need a minute to read this. So is the state changing the charges, or are the charges remaining the same?
The charges are remaining the same, Your Honor. What had occurred was, I believe, a Scrivener's error on the part of the officer with regards to the results in the affidavit, with regards to the results of the field testing of the cocaine and the fentanyl, Your Honor. In the initial report, it had said to test it negative. However, after contacting the officer, that was an error on his part. It was actually tested positive.
Your Honor,
In regards to PC.
Your Honor, I'm still not convinced it's the same affidavit. One word has changed from negative to positive. There's no evidence that they tested the substances again and it came back positive. And if you look at the Mr. Santiago's history, absolutely no history, or no convictions, no misdemeanors, no FTAs. And as to his out-of-state convictions and histories, none of them, I believe, are even drug-related. So I would have you have him released ROR on the drug charges, as he already has bond on the 3 other charges from yesterday.
Counselor, did you read the amended affidavit?
I did. It was exactly the same as the arrest affidavit, except it changed from negative to positive.
Right, because if it was a Scrivener's error, they corrected the Scrivener's error. So,
I would have tested it again just to confirm that, instead of having an affidavit that says negative and then going and changing it to positive.
so you would want the law enforcement officer to remove the evidence from the sealed evidence bag to field test it again, rather than send it to FDLE where it will be tested by a drug analyst?
I just think it's odd that he accidentally wrote negative when most of the time it comes back positive. I don't know the circumstances surrounding it, but
But what in this affidavit is not probable cause?
in the amended affidavit,
Right.
I'm still referring to the original affidavit.
But we have an amended affidavit now.
I understand, I'm still, just one word changed, just so the charges can stick. It is in your discretion, of course, Your Honor.
I also don't think that necessarily not having the field test means there's not probable cause. So even if the field test came back negative, I don't know that that means there's not probable cause. But since the field test came back positive, I think there's sufficient evidence to support a finding of probable cause. I'll stay the bonds as is. They were all treated as subsidiaries except for count one, which is $1,000. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
Sí.
Yes.
Good luck, sir. Now is that it for Spanish? Yes. All right, that's all we need from the interpreter at this time. Thank you.
Thank you, Your Honor. Will any of the witnesses need a Spanish interpreter?
Oh, that is a great question. Can we ask if they have any witnesses out there? No, we don't need any. Thank you.
Perfect. Thank you, Your Honor. Have a great weekend.
You as well. Oh, good for her for remembering that from yesterday.
You have the move up next, and then the private attorney after the move up.
Okay. Sir, please tell me your name.
Michael Aljo?
I'm sorry, one more time.
Michael Aljo?
21 CF 8134. You're here charged with aggravated battery and battery domestic violence. I'm going to appoint an attorney to represent you. Yes, sir.
I believe in the affidavit, the officer even stated towards the end that there was a computer error. He tried to put in a charge of by strangulation and instead put in a charge of aggravated battery, great bodily harm. Is that still the case, or has the current charge been amended?
I don't know. I have the same affidavit that you have,
Okay.
but there is probable cause for aggravated battery domestic by strangulation.
Yes, but is that a lesser charge than
It is not. It's the same charge.
as great bodily harm?
It is.
I didn't hear.
Okay.
It's the same statute.
Thank you, Your Honor.
Miss?
Yes, sir. I want to make sure you understand that. Listen, I want you to listen to me. Everything you say is being recorded and can be used against you later. Do you understand that?
Yes, ma'am.
So you can say anything you want, but the state of Florida can record it and use it against you later on in your case.
Okay.
So there's an attorney standing right next to you. If you want to talk to him, I'll give you a minute to do that.
Yes, ma'am, I do.
Just a moment, Your Honor.
All right. Sir, at this time, I do find that there's probable cause in this case. Yes, Mr. Brands?
Just a moment. I'll wait till you set bond, and then I would like to see the court.
All right. Your bond will be $5,000 on count one, $100 on count two. Sir, you can't have any contact with the victim. Do you understand what that means?
Yes, ma'am.
Okay. You can't possess a weapon, firearm, or ammunition. You can't live with her when you get out of jail. Do you understand that?
But that's my wife.
I know. But for right now, you're going to have to maintain a separate residence, and you can go back one time with law enforcement officers to gather your belongings, but you can't live with her right now. Do you understand?
I don't want to think.
What did you say? I can't.
Oh,
How long will it take?
Oh, that's until another judge changes my order. So you can ask your attorney to file a motion in front of the trial judge and ask that judge to allow you to have contact with your wife. But for right now, you can't. You understand? I need you to answer out loud. Thank you. All right, Mr. Rance, did you wish to be heard on something else?
May I approach?
Yes. Just one moment, Mr. Archer. The attorneys are doing some research for me.
and how long will it be?
I'm sorry? Just a moment. Hold on, I can't hear him. What did he say?
I'll talk to him, Your Honor.
Okay, thank you. You know what? At this time, I'm going to take no action on that case. Good luck, sir. Stay in touch with your attorney, okay? It's okay.
On that out on bond, Your Honor?
Yes.
You should have called us. Thank you, Your Honor.
Please tell me your name.
I'm John Hodgman.
21MO780. You're here charged with violating a city ordinance, to wit, bathing, swimming in a lake or privately owned beach as prohibited. There is probable cause. Was there an offer?
No, Your Honor.
All right.
Okay, I didn't have a chance to speak with Mr. Hodgman. I did have a chance to speak with other pleables, but may I have just a few moments? Your Honor, may we plead to the bench? As this is a city ordinance, and I don't know the circumstances of, as in the arrest affidavit, what happened, but would you accept a withhold of adjudication and credit time served?
Can I have the attorney's approach? All right, Mr. Hodgman, please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I do.
Thank you.
All right. You had a moment to speak with an attorney here. Did he talk to you about the rights you'd be giving up if you enter a plea of guilty or no contest to this charge?
Oh, no, yeah, no, I don't think, I just wanted to get this wrapped up.
Hold on, I need you to speak a little louder.
I'm sorry, I just wanted to wrap this up. I didn't see any trial necessary for swimming in a lake, and I just wanted you to know that it'll never, ever happen again. I'll leave Orlando if necessary. It's,
I'm not going to kick you out of the city, but I do want you to understand, we don't have to have a jury trial, but you might be entitled to one, and you're giving up that right today if you enter a plea of guilty or no contest. Do you understand that?
yes, ma'am.
You're
I mean,
also
yes,
giving
Your
up your
Honor.
right to remain silent. You understand that?
Yes, Your Honor. Am I making the right decision in your eyes?
I can't give you legal advice. I just want to make sure that you understand. So let me tell you what's going to happen. Here are your options.
Okay.
If you enter a plea of not guilty, we will not resolve this case today. It will be set in front of another judge at a later date.
Okay,
I will appoint an attorney to represent you, so you'll have an advocate working for you. If you enter a plea of guilty or no contest today, I'm going to sentence you today. The public defender has asked, as a friend of the court, if I will withhold adjudication and give you credit for the time that you've been in jail, which I am inclined to do. What that means is you will be released. But if we do that, you're giving up your right to remain silent, your right to a jury trial if one is required, your right to testify on your own behalf. If you enter a plea of guilty or no contest today, the case is over today.
sounds like the best plan.
Your Honor.
It could be if that's what you want to do. I just want to make sure that you understand you're giving up all of those rights to do this. That could be in your best interest.
Just one more, if I may have one.
Yes,
more,
go
Your
ahead.
Honor.
Oh, gotcha. I've seen you take these courtroom. Yeah. You had response to, I don't know what material that was.
Your Honor, can we be appointed in this case, please?
Yes.
We would just request ROR and a court date. He will contact our office to coordinate efforts to resolve this in court, as well as any services that Mr. Hodgman may need. Thank you, Your Honor.
Absolutely. I'm appointing the public defender's office to represent you. Is there a way to know what his next court date will be? I'm going to release him on his own recognizance. Hold on, we're going to get you a court date.
Thank you, Your Honor.
Yes, sir. But I'm also going to order that you can't go back to Lake Eola.
Okay,
You understand?
yes, ma'am.
All right.
Can
Robert?
he be within like a certain number of feet of the lake? As it is a park.
Do you need to go back to the park?
Oh, I was just curious if it was, I had some squirrel and swan friends over there. No, if you prefer me not to, I just want to resolve this today however possible, and I won't.
So if I release you on your own recognizance, we're not going to resolve, it's not going to be over today.
I see. I have a court date.
Right, you're going to have to come back and see a different judge. It won't be me. It'll be downtown.
That's fine.
But you have an attorney working for you. They'll negotiate with the state of Florida, and I don't know what the state will do with this case. The state can drop it, they can prosecute it. It's completely up to them.
Understood.
All right, hold on 1 minute.
The arraignment will be July 27th at 7:30.
Which Jewett?
Courtroom 4B.
All right, so you're going to see Judge Steve Jewett,
Okay,
July
27th.
27th at 7:30 in the morning.
how long away is that?
Courtroom 4B.
Yes.
I'll figure that out, yeah.
So talk to your attorney, okay? Keep in touch with your attorney.
Yes, yes, Your Honor.
All right, good luck, sir.
I,
Yes.
thank you.
Good luck. Yes, sir.
Thank you, Your Honor.
Yes, sir. Please tell me your name, sir.
Samuel Paul.
21 CF 8148. You're here charged with grand theft of a motor vehicle. I'm going to appoint an attorney to represent you. There is probable cause in this case. Your bond is $1,000. You're not allowed to have any contact with the victim or the co-defendant in the case. Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir.
Your Honor, if it's possible, Bryant Williams went to the restroom.
Yes.
Went to the next inmate.
Please tell me your name.
Jonathan Rico.
A warrant was issued for your arrest in 21 CF 8006, charging you with sexual battery on a child under 16 and lewd and lascivious battery. Another judge has already found probable cause. I'll appoint an attorney to represent you. Does the state wish to be heard on bond?
No, Your Honor, the state would ask for a high bond, but the state would leave it to the judge's discretion, Your Honor.
Doesn't count one a first-degree felony punishable by life in prison?
Yes, Your Honor.
So at this time, he'll be held at no bond.
No argument, Your Honor, pending an Arthur hearing downtown.
On count 2, your bond will be $100,000. Even while in custody, you can't have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
On count 2, you can't have any contact with any minor children under the age of 18. You can't return to the victim's residence for any reason, be within 1,000 feet of her residence. All right, that's all.
Thank you, ma'am.
Good luck. No, count 2 is 100,000. Count 1 is none. Please tell me your name.
Yvette Mills.
One more time.
Yvette Mills.
21 CF 2694. You're here because a capias was issued for your arrest for failing to appear for a case management conference on a charge of possession of cocaine. There's no bond authorized on that capias, and I'll appoint an attorney to represent you. Good luck.
Is it?
That's it.
I didn't even know I had it.
Good luck.
Your Honor, which case was that? Yeah, oh, thank you.
I think we're still waiting on Bryant. Please tell me your name.
Robert Helmuth.
What? Robert Helmuth. 21 CT 628, you're here charged with driving under the influence. There is probable cause in this case. I'll appoint an attorney to represent you. Your bond is $500. You can't drive without a valid Florida license. You can't possess or consume any alcoholic beverages or any controlled substances without a valid prescription. And at this time, I'm revoking your out on bond case, 2019 CF 12056. Good luck. Please tell me your name.
William uppercase W, lowercase LLIMA.
Is your last name Bryant?
Yes, capital B, lowercase RAYANT.
Thank you. You're here in 21 CF 8157, charged with lewd or lascivious exhibition, offender over 18 years old, victim less than 16 years old. I reviewed the probable cause affidavit. There's probable cause in this case. I'll appoint an attorney to represent you.
Could I ask the court?
Yes.
Go ahead, I'll wait till you finish.
I'm sorry, go ahead, sir. I didn't mean to cut you off. Thank you.
Thank you, Your Honor.
All right, sir, your bond is $25,000. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am. Could I ask you something also?
Yes, sir.
With the bond, since you gave me a bond, could I ask the court to certify my subrogation on it?
Get closer to the mic so I can hear you. You have to leave your mask on.
I said, since you gave me a bond, could I ask the court to certify my subrogation on this, on the financial part?
I'm still having trouble hearing. Mr. Brands, can you tell me what he's asking?
Certify subrogation? Yes.
I don't know what that means.
Actually, in civil law, it says, you don't understand what subrogation means? In civil law, if I have it, then the person who probably drives up that day, pays that. It applies here. Could you tell her what I asked you?
He's referring to a right, I guess, in civil proceedings that someone else can pay if he.
I know what subrogation is.
Yes. And I want to certify, if I can ask the court to certify my subrogation on this financial situation.
I'm not sure that's necessary in this case. Anyone can post your bond.
I'm not talking about a bond, I'm asking about to certify my subrogation.
Right, I don't think I can do that, but you can have your attorney file a motion in front of the trial judge at a later date. But let me finish. You're not allowed to have any contact with any minor children under the age of 18. You can't possess a weapon, firearm, or ammunition. Are there any other conditions the state would request?
No, Your Honor.
Good luck, sir. Stay in touch with your attorney.
I didn't know, she told me she was 18. I didn't know.
I understand. I know what subrogation is, but I don't know how that's relevant. Mr. Brands, I'd like to see that motion, however, when you file it. Please tell me your name.
Erica Tavares.
Good morning, Counselor. Would you like to put your appearance on record?
Good morning, Judge. Darrell Smith on behalf of Ms. Tavares.
This is 21 MM 4756. Ma'am, you're here charged with battery domestic violence. Counsel, did you want to make an argument as to probable cause?
No, Your Honor, just the victim is present to testify as to contact.
All right, please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
Jose Arzeno.
Did you wish to inquire, Counselor?
Yes, Your Honor, if I may. Good morning, sir. Could you state your name and spell your last name for the record, please?
It's Jose Arzeno, Josearzeno.
Thank you. And how do you know Ms. Tavares?
We met her like 3 years ago.
Okay, that's your wife?
Yeah, I mean, we not married, but we've been living together for like 2 years, almost 3 years.
Okay, so you guys have been together for 3 years?
Yes.
And do you want her to return to the household?
Of course, yes.
Okay. Are you afraid of her at all?
No, at all.
Okay. Are you in fear of any future acts of violence if the court were to let her out?
No.
And do you understand what no hostile contact means? I know we talked about it a little bit yesterday. That if the court orders that Ms. Tavares have no hostile contact with you, it means you can't no argue, no fighting, no pushing, no shoving. And you understand that if she were to do those things, you could call the police.
Yes.
Okay. And would you have any problems calling the police if there were any further acts of violence?
I don't think it's gonna be another problem,
Okay.
another situation to call the police.
Okay. Do you want her to return home?
Yes.
Do you all have kids together? No.
No.
All right. Has there been any prior acts of domestic violence?
Use relationship fights?
Okay. But never anything physical before this?
No.
All right. I don't have any further questions. Thank you.
Does the state have any questions?
Yes, Your Honor. Why are you here today?
I'm sorry?
Why are you here today?
I'm the victim on the case, and I don't wanna put charge, I don't wanna do I don't want her to put any contact or no contact order on her.
How are you a victim?
I'm sorry?
How are you a victim?
I mean, I'm the victim because we was fighting in the morning, and we was having like a regular fighting relationship, and I was afraid for her to call the police because her cousin was home, but her cousin was locked up in the room and she didn't want to get out. So I called the police, and her cousin called the police. When the police got to the house, I started talking to them. I told them that we was fighting, we was just fighting.
What kind of fighting were you doing?
I mean, it was about a text message. So I was trying to get her phone away. She was trying to get my phone too. It was just regular fighting, trying to take the phone away.
Thank you. No further
problem.
questions, Your Honor.
Counsel, did you wish to be heard on bond?
Yes, Your Honor. Ms. Tavares has no criminal history. And as you can see, she's been with the victim for about 3 years. They live together. I would ask that the court not put a no contact order in place, put no hostile contact. And as to bond, if the court would consider RORing Ms. Tavares, if not, I would ask for straight PTR. If Your Honor is inclined to do bond and PTR, I would ask for the lowest possible bond.
Does the state have any objection to pretrial release?
No, Your Honor.
All right, at this time, ma'am, I'm going to place you on pretrial release with special conditions. You can't have any hostile contact with the victim. Do you understand what that means?
Yes.
Peaceful contact only. Don't even raise your voice. You have
Yes.
to answer out loud. Thank you. You can't possess a weapon, firearm, or ammunition. Are there any other conditions the state would request?
Yes, Your Honor. No drugs or alcohol.
Was alcohol involved in this incident?
Just as an abundance of caution, Your Honor, I believe I read that, but
I'll order that you're not allowed to possess or consume alcoholic beverages or any controlled substance without a valid prescription. Do you understand?
Yes.
All right, good luck. Thank you, Counselor.
Thank you, Judge. Have a good day.
You as well. Thank you, sir. Do we have Creole next? Okay. All right. Right. We don't have Creole. We're on hold.
Oh, okay.
Can we take someone else while we are on hold?
Love you, Your Honor.
Did Stellene Pierre Saint,
She also needs Creole.
oh, she needs Creole? I don't have a face sheet for her. So she didn't bond out?
No.
But I don't have a face sheet, so that's weird. All right, well, can we take a case that doesn't need Creel? Who else do you guys have in there? All right, let's do that one. Shawnee Clay, 21 CF 8141. Counselor, I'm going to appoint your office to represent her. She's in the hospital. Do you want to waive her appearance, or do you want to reset this?
I'd like to reset it, especially with the charges. It reset 24 hours after release from the hospital.
We can do that. Can you do that?
We're resetting it.
24 hours after release, within 24 hours of release from the hospital? All right. Please tell me your name.
Ricardo Delgado.
21 CF 7605. You're here because a warrant was issued for your arrest, charging you with battery with 2 prior convictions and battery domestic violence. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Your bond will be $2,500 on count 1, $500 on count 2. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you may not coordinate that with the victim. Do you understand?
Yes, ma'am.
All right, good luck. Just tell me when you have them. Please tell me your name.
Hadley Edwards, ma'am.
21 CF 8152, you're here charged with aggravated assault with a deadly weapon and aggravated battery with a deadly weapon. I'm going to appoint an attorney to represent you. There is probable cause in this case. Your bond will be $1,000 on count 1, $150 on count 2. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Yes, ma'am.
You can't possess or consume alcoholic beverages or any controlled substance without a valid prescription. Good luck. Please tell me your name.
Ashley Fairconshore.
21 CF 8171, you're here charged with burglary of a dwelling with assault or battery, battery, domestic violence, assault, and petty theft. I'm going to appoint an attorney to represent you. Mr. Brands, did you wish to be heard?
Yes. Your Honor, if you've read the arrest affidavit, you'll see on the first page, second paragraph from the bottom, I guess third paragraph from the bottom, I have a PC argument as well on the burglary of the dwelling. I believe the order of the facts go that there may have been an alleged battery and then a rescinding of the license to be in the house. Ms. Conacher was allowed in the house due to her broken air conditioning. And I believe the license was revoked after an alleged battery. I would have you consider that in determining PC for the charge.
So which charges are you saying there's no probable cause for?
Burglary of a dwelling with assault or battery.
All right, is that the only one?
Yes, Your Honor.
All right. What says the state?
Your Honor, in the affidavit, it says that the invitation was explicitly revoked, and then she there and after battered him in the apartment. But if this honorable court does not find PC, the state would ask for 24 hours to correct any PC errors.
Your Honor, may I recite the line that I have here in the affidavit?
Yes.
To that same paragraph, second sentence, third sentence from the bottom. Williams picked her up and she bit him on the neck. Williams pushed her outside of the apartment and she asked him to get her stuff for her.
I'm sorry, which paragraph are you reading?
On the first page, it's the second full paragraph from the bottom, not including that line.
Okay.
And third sentence from the bottom of that paragraph. Williams picked her up and she bit him on the neck. Williams pushed her outside of the apartment and she asked him to get her stuff for her. I believe one took place before the other.
All right, hold on, I've got to reread this again. All right, so I understood that the burglary was from a different paragraph. The last paragraph on the page. Williams then heard her bust, quote unquote, into the bedroom, watched her pull Mace out. Because Ward's 2-year-old and 5-year-old were on the bed, Williams intervened and told her to get out. She refused to do so and said she was going to, quote, beat Shakira's ass. Williams grabbed her under the arms. She began kicking, punching and biting him. He pushed her out of the apartment. That's when she grabbed the ring. So I understood the burglary with assault to be when she, quote, busted into a room which she was not invited into with Mace and verbally threatening the individuals in the room.
So you would find PC, Your Honor?
I think that you raise an interesting question, Counselor. I need to consider it. Let's take the Creole cases and pass this one and come back to it. So we're going to come back to this case in just a moment. I guess. This is Judge Gibson. Who do I have on the line?
Yes, good morning, Judge Gibson. I'm the interpreter. My name is Marie, and my ID number is 200769.
Has the interpreter been sworn today?
Not yet, Your Honor.
Please raise your right hand to be sworn.
Do you solemnly swear to translate from Creole to English, from English to Creole to the best of your ability?
I do solemnly swear, Your Honor.
Thank you. Please ask him to tell me his name.
Monsieur, s'il vous plaît, dis juge la nom.
Bordenave Emmanuel.
Bordenave Emmanuel.
21 CF 8160. You're charged with aggravated battery on a pregnant person, domestic violence.
Et dit comme ça que ça dit qu'on fait, yo ouais qu'on y a une forme de violence quand on bat une femme coup pendant mon enceinte, c'est une forme de violence domestique.
There is probable cause, and I'll appoint an attorney to represent you.
Il dit yo cap gain cause probablement. Il dit la fait il a besoin d'un avocat pour représenter.
Oui, merci.
Yes. Thank you.
Your Honor, he does otherwise qualify for PTR.
I don't think she'll be able to hear you, Counselor.
He does otherwise qualify for PTR, Your Honor.
Can you repeat that, sir?
Your Honor, he does otherwise qualify for pretrial release.
L'avocat a demandé que monsieur a qualifié pour laguer avant qu'on aille dans le tribunal.
What says the state?
The state would be opposed to pretrial release, Your Honor, given the charges.
Il dit de ça que je dis que vous faites.
I'm going to place you on pretrial release and require that you post a monetary bond of $2,000.
Il dit comme ça qu'il a plagué, mais il a fait payer une forme de caution de $2,000.
With special conditions, you can't have any contact with the victim. Do you understand what no contact means?
Il dit avec une condition spéciale qu'on pas fait pour gagner aucun contact avec femme nan. Est-ce qu'on comprend? Ça veut dire ou pas gain contact.
Moi comprends, mais sauf que c'est dans cas là moi gagne bagage moi il faut contact une assistance me retirer aussi me pas contact pour avec.
I understand, but it's in the house that I live, so I would need some form of assistance to get my belongings.
Yes, I'm going to order you must maintain a separate residence, and I'll allow you to return one time with law enforcement to gather your belongings.
Il dit oui, il peut quitter ou aller pour une fois seulement pour aller prendre bail pour qu'elle cherche l'autre côté pour vivre.
You can't possess a weapon, firearm, or ammunition.
Il dit comme ça qu'on pas fait pour qu'une forme de arme ou bien qu'une forme de ammunition avec eux.
Non, moi pas utiliser bagage comme ça.
No, I don't use things like that.
Then that will be easy.
So ça suppose c'est facile.
Good luck, sir.
Il dit bonne chance, monsieur. Anything else, Your Honor?
No, thank you. We have one more case, though.
You're welcome. Okay.
We have one more interpreter case.
Okay.
Ma'am, please come to the podium.
Il dit, madame, si vous pouvez venir devant lui.
And tell me your name.
C'est qui nom, s'il vous plaît, madame?
Yersin Stillen.
M'attendons bien.
Yersin Stillen.
Yersin Stillen.
Stillen. Stillen.
Stillen.
S-T-E-D-Z-E-F-N-E.
You're here in 21 CF. Oh, I'm sorry. 8144, charged with aggravated assault, domestic violence.
Il dit comme ça que, so gen c'est 8144, il dit que ou t'es dans kouma ou moun domestique.
There's probable cause. I'll appoint an attorney to represent you.
Il dit pour cause probablement l'a fait un avocat pour représenter.
Sir, do you need a Creole interpreter and do you wish to testify this morning?
I'm fine.
I'm going to have her still.
Moi-même.
I didn't get a chance.
I'm going to have her interpret for her.
Okay.
All right. Please raise your right hand, sir.
Okay. Okay, levez mes droites, s'il vous plaît.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I want to keep her in the house. I want to keep her in the house.
Hold on. I need you to answer that question.
Speaking English. Est-ce que vous faites serment pour dire la vérité, seulement la vérité, monsieur?
Oui.
Yes.
Please state your name for the record.
S'il vous plaît, dis non pour dossier.
Serge Telfort.
Serge Telfort.
Sir, how do you know Miss Pierre Saint?
We are husband and wife.
Lizzie, madam, monsieur, okay, he's speaking in English, so do you still want me to interpret?
I want to make
You
sure
don't
that the
want him at-
defendant can understand.
Okay. Demandez, monsieur, excuse me, qui côté comme them? Excuse me, Your Honor.
It's okay.
Demandez, monsieur, à qui j'en connais, madame Pierre Saint. Monsieur a dit que vous c'est madame et mari.
Sir, do you wish to have contact with your wife?
I want she live in the same house. We have to live in the same house.
Si vous voulez et que vous restez dans la même caille, monsieur a dit nous devons rester dans la même caille.
Are you afraid of her?
No, she's not. You know, she probably faced some little thing, but she's a good person.
Demandez Mario s'il peut ou, monsieur a dit non. Pour son bon monde, c'est petit bagay.
At this time, I'm going to place you on pretrial release, Miss Pierre Saint.
Il dit pour qu'on y a madame Pierre Saint, il a plagué ou, vous comprenez? Avant qu'on aille dans le jugement.
With special
Madame Pierre Saint.
I'm so sorry, I thought you were done.
I'm done now, Your Honor.
With special conditions, you can only have peaceful contact with your husband.
Il dit avec et conditions spéciales, ou cap juste faire contact avec lui, avec barre de paix. Vous comprenez?
Yeah, she's cool. She's very cool. Everything will be great.
Okay, you can't possess a weapon, firearm, or ammunition.
She don't have anything like that.
Okay.
Il dit qu'on sa ko pa kap gran ken zam nan kay la madame. E ma ou di ou pa gran ken bay kon sa. I don't have things like that.
All right. Good luck, ma'am. Thank you, sir, for
Thanks so
coming.
much.
Good luck.
All right.
Il dit bonne chance et merci beaucoup veni.
And I believe at this time we have no further Creole cases.
Okay. Thank you.
you.
Have a wonderful day.
You as
You're
well.
welcome. Thank you.
Please tell me your name.
Luckner Florimo.
21 CF 8165. You're here charged with domestic battery by strangulation. There is probable cause, and I'll appoint an attorney to represent you. Your bond is $5,000. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
Your Honor, I think there's a victim out there.
Oh, just a moment. Do you wish to testify?
Yes.
Please raise your right hand to be sworn. You look at me.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, to help you God?
Yes.
Please state your name for the record.
Sanguinita Smith.
Ma'am, how do you know the defendant?
He's my ex-boyfriend.
Are you afraid of him?
Yes.
Do you want to have any contact with him?
No.
Were you two living in the same house?
Yes.
All right. Does the state wish to ask any questions?
No, Your Honor.
Does the defense have any questions?
No questions, Your Honor.
All right, Ms. Smith, is there anything else you want to say to me?
Yes. At this point, it's just to the point where I don't want to see him locked up, but he's so nonchalant. Like, he does not care. He does not see any wrong in anything that he does. This has happened several times before. This is not the first time, but I'm just tired of it, and I cannot continue to fight this man.
Does he have belongings at your residence?
It's an apartment that we share together. Yes, he does have clothes there.
All right, here's what I'm going to do. You're not allowed to have any contact with Ms. Smith. You understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate
Yeah.
residence.
I'm sorry.
I'm sorry, go ahead.
He has a firearm at the house, at the apartment.
Since it's not alleged in this incident, I don't know that I can order it to be surrendered, can I?
Well, he's legal, like he has his license or whatever.
He can't
but-
possess it at this time. Can I order him to surrender it? State?
I believe so, Your Honor. I'm not 100% on that.
I believe you can pending the duration of the trial.
All right, I'll order that you have to surrender that firearm and ammunition to law enforcement within 24 hours of your release. I'll allow you to return one time to the residence with law enforcement to gather your belongings, but you can't coordinate that with Ms. Smith. Do you understand? Ms. Smith, was there any alcohol or drugs involved in this incident?
He was, no, I don't think so. I don't think he was intoxicated. No.
All right. Once you've gathered your belongings, you can't be within 1,000 feet of her residence or place of employment. Do you understand?
But Your Honor,
Yes.
with our apartment, we have a agreement with his father, who also has an agreement with the apartment complex. With it being in his father's name, is it gonna be a problem with me being there?
Not lawfully, not having anything to do with this case. The court doesn't have jurisdiction to order you to leave. I only have jurisdiction over him.
Okay.
Hold on, there was something else I was going to order. You also can't have contact with any of the witnesses in the case. Do you understand that? Yeah. All right, good luck, sir. Thank you, ma'am. Good luck.
Your Honor, Junico Buela Julio is in the hospital.
21 CF 8159. Counsel, I'm going to appoint your office.
What was the reason?
They're in the hospital.
Oh, yes, can we reset that as well? 24 hours within release from the hospital, Your Honor.
Yes, but you understand that by doing that, he's going to continue to be held at no bond. I'm okay to do that. It's your client. I just want to make sure you understand. You're asking the court to continue to hold your client at no bond.
In lieu, Your Honor, we'll just waive the appearance. We'll set bond conditions today.
It's up to you. I don't have a preference either way.
I have a PC argument with the charge, Your Honor. Or a PC question, I suppose.
All right, go ahead.
I will waive the appearance.
I'll appoint you. I did. Now, go ahead and make your argument.
I believe it's a charge of aggravated battery with a weapon, and I believe the arrest affidavit states that he was poking the alleged victim with a mic stand. I don't know if there's any case law that suggests that a mic stand is a weapon.
I don't know if there's any case law directly on point with microphone stands, but I recall there's case law that says even a plastic fork can be a deadly weapon. What says the state?
Yes, Your Honor, I don't believe that the Florida statutes have defined weapon with regards to a mic stand. However, I'd have to agree with this honorable court with regards to how that item is used. From the case law that I'm familiar with, it's primarily related to how the item is used, and if used in a violent manner, then what can be a weapon is very broad, Your Honor. So I wouldn't say that was a PC issue.
Also, the circumstances surrounding this charge have another party as presumably the aggressor. I believe the party's name is Martin. I believe a fight was trying to be broken up between Martin and another party. And Mr. Kubela may have been involved in trying to break up that altercation. The closest thing I see as to PC would be normal battery, domestic violence, I suppose, if they live together.
It says there was an argument. It continued as Publio took out a mic stand and began jabbing it toward Martin. The mic stand struck Martin multiple times on his left arm. He then left the house and called 911 for assistance. He advised that Publio used the jabbing motion to strike him with the mic stand.
But there are other circumstances where Publio was trying to break up an altercation between Martin and I believe his wife.
That's Publio's statement.
Correct, Your Honor, and considering the totality of the circumstances.
Based on the affidavit, I do find there is probable cause. I'll set the bond at $5,000, no contact with the victim, no weapons, firearms, or ammunition, maintain a separate residence, one-time return with law enforcement. Please tell me your name.
Manuela Tervius.
21 CF 8161. You're here charged with aggravated battery with a deadly weapon. There is probable cause, and I'll appoint an attorney to represent you.
Just a moment, Your Honor. Your Honor, may I approach?
Yes. I didn't place him on pretrial release.
I'm gonna be in Fort Lauderdale anyway.
All right, ma'am. Wait, no. No, I just want to see it. Sorry. You don't have any arguments to make in this case, counselor?
Other than similar conditions of release, if not PTR, then I guess PTR would be my request, Your Honor. It says she doesn't otherwise qualify, but no criminal history.
What's the aggravated battery with a deadly weapon?
Are you asking the defense, Your Honor?
Any attorney in the room?
I believe the arrest affidavit states that the alleged victim may have said a crystal ball was thrown in a picture frame, and then there was also further evidence that a picture frame was thrown, and that, yes. This is all within the four corners of the arrest affidavit.
Mm-hmm. What does it say before that?
I understand the argument you're making, Your Honor. I don't.
The two began to argue. He slapped her with an open hand to her face. She responded by striking him with an open hand. They continued to argue. He punched her in the face with a closed fist 3 to 4 times.
Your Honor, if I may, our office represents both of them at this time. That's why I'm hesitant to argue one against the other. They're both our clients at this time, Your Honor.
I don't see how whether there's probable cause in this affidavit against her has anything to do with him.
It is within your discretion to find PC on this charge, Your Honor. If you do not find PC, I would have you release your ROR on this charge.
I suppose as he was leaving the room is when she grabbed the picture frame and threw it at him. I guess there's probable cause, however thin. Why doesn't she qualify for pretrial release?
It looks like we weren't able to make any verifications for her. Her fingerprints also haven't cleared,
Okay.
so she hasn't been positively identified yet.
All right. All right, ma'am, your bond will be $500. You're not allowed to have any contact with the victim. Do you understand what no contact means?
No problem.
You can't possess a weapon, firearm, or ammunition. You two have to maintain a separate residence, and I'll allow one-time return with law enforcement to gather belongings. I ordered him to do the same thing. So you just can't stay together right now.
Can I ask you a question?
Yes, ma'am.
Do you know for how long?
That you can't have contact until another judge changes that order.
Okay, no problem.
So if you want contact, you both have attorneys, have your attorneys file motions in front of the trial judge, and they can change that order.
No problem, thank you.
Yes, ma'am, good luck.
All right.
Sorry, I had to keep it. Please tell me your name.
Andre Lewan Chu.
21MM4758. You're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You're not allowed to have any contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Good luck. Please tell me your name.
James Daniels.
21MM4766. You're here charged with battery domestic violence. There is probable cause, and I'll appoint an attorney to represent you. Your bond will be $500. You're not allowed to have any contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. Were you living with your father?
No, ma'am. Oh, no, Your Honor.
All right, so you don't have any reason to return to his residence?
No.
All right, I'll order no return to his residence. At this time, I'm revoking your bonds in 20 CF 1929 and 20 MM 4870. Good luck.
I have to stay.
Yes. Please tell me your name.
Alexander Flowers.
21 MM 4754. You're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Does the state object to pretrial release?
No, Your Honor.
I'm going to place you on pretrial release with special conditions. You can't have any contact with the victim or any witness in this case. Do you understand?
Yes.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. Are there any other conditions the state would request?
No, Your Honor.
Good luck.
So I can't go.
I'm sorry, I can't hear you. You can't live there if she's living there.
She's not on the lease. I live there.
It doesn't matter who's on the lease. If she lives there, you can't live there. This court doesn't have jurisdiction to order her to do anything, only you. But you can go back one time. Yes, you can go back one time with law enforcement to gather belongings. Please tell me your name.
Audrey O'Brett.
21 MM 4755. You're here charged with battery domestic violence. There is probable cause, and I'll appoint an attorney to represent you. Does the state object to pretrial release?
No, Your Honor.
I'm going to place you on pretrial release with special conditions. You can't have any contact with the victim or any witness in this case. Do you understand? You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you two can't coordinate that with each other. You understand? All right, good luck. Please tell me, oh, sorry. Please tell me your name.
Roberto Bennett Jr.
I'm sorry?
Roberto Bennett Jr.
21 CF 8149. You're here charged with possession of MDMA, possession of cannabis less than 20 grams, and trespass in an occupied structure. I'm going to appoint an attorney to represent you. There is probable cause in this case. Your bond is $1,000 on count 1, $100 on count 2, and $100 on count 3. You're not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
You can't return to the Marathon gas station located at 6415 West Colonial Drive. Do you know where that is?
Yes, ma'am.
Don't go back there.
Yes, ma'am.
What says the state as to his out on bond case?
Your Honor, the state would ask that they be revoked.
I'm sorry?
The state would ask that the out-of-bond cases be revoked, bond of those cases.
Mr. Brantz?
Can the state provide a reason as to revocation?
Your Honor, the new law violation, Your Honor.
Your Honor, he wasn't found with the same drugs he's out on bond with as well. These are nonviolent offenses, trespass included, other than the harm to oneself. I would just have you take no action on those out on bond cases, but if you are inclined, just to set a higher monetary bond, Your Honor.
He's out on bond on drug charges and he's arrested on new drug charges, Counselor.
I understand, Your Honor.
I'm going to take no action at this time. Please tell me your name.
Tabitha Bozart.
In 20 MM 5653, a capias was issued for your arrest for failing to appear for a pretrial conference on charges of petty theft and resisting merchandise recovery. Your bond is $1,500 on count 1, $1,000 on count 2, and I'll appoint an attorney to represent you. In 21 CF 1010, A capias was issued for your arrest for failing to appear for a pretrial conference on charges of possession of dilaudid and possession of drug paraphernalia. Your bond is $500 on count one, $100 on count two. I'll appoint an attorney to represent you. Good luck.
Can I get a status update on Bellamy, Jonathan Bellamy? I think he was in.
I just skipped him, I don't know.
I'm sorry, Your Honor, he refused.
21 CF 8155. I find his refusal a willing waiver of his appearance today in court. There is probable cause in his case. I'll stay the bond at $1,000 on count one, $150 on count two. Appoint an attorney. He's not allowed to return. He can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers.
Your Honor, as to the out on bond cases, again, similar argument as to the nonviolence. I believe the out on bond case were small amounts as well as the current charge were small amounts of contraband as well as illicit substances.
I'm going to take no action on this at this time.
Your Honor.
Please tell me your name.
Charisma Hall.
21 MM 4764. You're here charged with criminal mischief. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You're not allowed to have any contact with any victim or witness in this case. Do you understand?
Yes, ma'am.
In 21 CF 8158, you're charged with burglary with assault or battery and battery. There is also probable cause for these charges. I'll appoint an attorney to represent you. Does the state wish to be heard as to count one bond?
Yes, Your Honor, the state would ask for no bond.
Your Honor,
Because it's a first-degree felony punishable by life.
I understand, Your Honor. And after reading the arrest affidavit, I believe the alleged action was reached into the car and struck the victim. I don't believe there was legislative intent as to the burglary statute to include reaching into a car and striking someone. Burglary insists that there's a dwelling of some sort. I would have you just set a high monetary bond to ease any tensions this court might have, but I don't believe that there's proof evident presumption great to hold her at no bond.
Counsel, the court is bound by the law as written. 81002 of the Florida statutes, sub 2, says, all right, so let's start with the definition of burglary. Means entering or remaining in a dwelling, a structure, or a conveyance with the intent to commit an offense therein. Burglary is a felony of the first degree, punishable by imprisonment for a term of years not exceeding life if in the course of committing the offense, the offender, sub A, makes an assault or battery upon any person. The plain reading of the statute includes exactly the facts that are alleged in this affidavit.
So do you find proof, I believe it's the state's burden to show proof evident presumption great to hold a no bond.
If you're asking me to make that determination, Counselor, I will do that at this
I
time.
believe it's the state's burden, Your Honor.
I have the affidavit in front of me. They don't have to present any further evidence if I can find it based on the facts in the affidavit.
If you do find proof evident presumption great, she still does have or is entitled to an Arthur hearing downtown, as case law from the 5th DCA does suggest.
Case law suggests that, but the court downtown may have a different interpretation. So I want to make sure that you and your client understand that what you're asking this court to do is find proof evident presumption great, which I will do at this time. Whether the judge downtown will allow you to have a full Arthur hearing is up to that judge. This court can't order that. There is, however, proof evident presumption great that your client committed a burglary with a battery in this case, and a battery. At this time, you'll be detained with no bond on count one. Count two, your bond will be $100. You're not allowed to have any contact with any victim or witness in this case. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. You can't return to this scene for any reason. Good luck. Please tell me your name.
Bonnie Hampton.
21 CF 8140. You're here charged with possession of synthetic cannabinoids. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
Yes, ma'am.
As to the,
Out on bond.
Oh, hold on, we have another case.
as to the out on bond case, Your Honor, I believe she has participated in pretrial diversion under Judge Cameron. I would just have you take no action to allow her the opportunity to complete that pretrial diversion.
I'll take no action at this time. Good luck, ma'am.
Thank you.
Please tell me your name.
A.B. Moses Harrell.
All right, sir, you have a warrant in 21 CF 8050 charging you with grand theft retail. Another judge has already found probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can't return to the scene or have contact with any witness in the case. Do you understand? In 21 CF 3760, a capias was issued for your arrest, charging you with grand theft. The bond authorized is $5,000. I'll appoint an attorney in that case as well. 3760. You can't have contact with any victim or witness, and you can't return to the scene of this offense either. Yes, sir.
I bonded out already on him.
On the capias? I don't know about that. That might have been a different one. You have several cases.
Multiple cases.
You have a warrant in 21 CF 5755 charging you with grand theft. Another judge has already found probable cause. Your bond is $1,500. You can't have contact with the victim and no return to the scene in that case either, and I'll appoint an attorney to represent you. In 21 CF 7053, a warrant was issued for your arrest, charging you with grand theft. Your bond is $2,500. You can't have any contact with any victim or witness in that case. I'll appoint an attorney to represent you.
Your Honor, may I approach?
Yes, just one moment. Did I get all the cases that are pending?
There's one more, Your Honor, 2021
MM 4760. You're charged with resisting an officer without violence. There is probable cause for that charge. I'll appoint the Public Defender's Office to represent you.
Can that bond be set as a subsidiary to the other charges?
Yes, I'll set that bond at $100.
May I approach?
Yes. At this time, I'll take no action on the out on bond cases. Good luck, sir.
Your Honor, Jenny Herrera, refused.
21 CF 8135, I find her refusal a willing waiver of her appearance today. There is probable cause. I'll appoint an attorney. Her bond is $1,000 on count one, $100 on count two. Not allowed to possess or consume controlled substances or have contact with any known drug dealers. Please tell me your name.
Cheryl Hodge.
21 CF 8142. You're here charged with grand theft of a motor vehicle and petty theft of $100 or more. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $1,000 on count one, $100 on count two. You're not allowed to have contact with any victim or witness in this case. Do you understand?
Yes, ma'am.
Good luck.
I do have one question.
Yes, ma'am.
If
Just get closer to the microphone.
I'm sorry. if my belongings are there
Or where?
at this resident where I can't have any contact, how do I get my stuff?
Talk to your attorney about it.
Yes, ma'am.
So the victim is the owner of the residence?
Absolutely.
Can you order a one-time?
Yeah, I'll allow one-time return with law enforcement to gather your belongings.
Okay, thank you.
Yes, ma'am. I didn't, but because the victim is the owner of the residence where the things are, she wouldn't be able to go back there. Mm-hmm.
Your Honor, Luke Montravius bonded.
Okay. Bonded. Please tell me your name.
I'm Julian McIntosh, ma'am.
21 MM 4762, you're here charged with trespass on property after warning. There is probable cause. I'll appoint an attorney to represent you. Your bond will be $100, and you're not allowed to return to the Food Lotto convenience store. Do you know where that is?
Oh, yes, sir, ma'am.
Don't go back there. In 21 CF 8153, you're here charged with possession of cocaine, possession of drug paraphernalia, possession of cannabis under 20 grams. There is probable cause for this as well. I'll appoint an attorney to represent you.
Can you make the two charges subsidiary, Your Honor?
I can't hear you. What?
Can you make the two additional charges subsidiary to the possession of cocaine charges?
Yes, I will treat them as that. Your bond on count 1 is 1,000. Counts 2 and 3 will be 100. No contact with any known drug dealers. You're not allowed to possess or consume any controlled substance without a valid prescription. Do you understand?
Yes, ma'am.
I'm inclined to revoke his out-on-bond case, Counselor.
Just a moment, Your Honor. Your Honor, I believe on that case, he is in the process of entering a plea. It didn't come out as pled, but our office has been working with Mr. McIntosh to enter that plea. I would just have you take no action on that as that process can be resolved.
I'm not going to do that. Based on the facts that are alleged in the current affidavit and the charges in the out-on-bond case, at this time, I'm revoking your bond in that case. But it won't affect his ability to continue to work and resolve that in front of the trial judge. Good luck. Please tell me your name.
Vincent Sinclair.
All right, sir, in 20 CF 10235, a capias was issued for your arrest for failing to appear for a hearing on charges of possession of a firearm by a person found to have committed a delinquent act and carrying a concealed firearm. There's no bond authorized on that capias, and I'll appoint an attorney to represent you. In 21 CF 5904, a warrant was issued for your arrest, charging you with possession of a firearm by a convicted delinquent. Another judge has already found probable cause. Your bond is $4,000. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
In 21 CF 8136, you're here charged with possession of oxycodone and resisting an officer without violence. There's probable cause, and I'll appoint an attorney to represent you. Your bond is $1,000 on count 1, $100 on count 2. You're not allowed to possess or consume any controlled substance or have contact with any known drug dealers. Do you understand that?
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
Jose Angel Soto Gonzalez.
21 CF 8146. You're here charged with possession of fentanyl, possession of drug paraphernalia, and driving while license revoked, third or subsequent offense. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,500 on count 1, $100 on count 2, and $150 on count 3. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. And you can't drive without a valid Florida license. Do you understand that?
Yes, ma'am.
And I'm revoking your out on bond case, 21 CF 909.
Your Honor, would you consider just setting a higher monetary bond? I believe he is the sole caretaker of his mother.
Yes, ma'am.
I would not, based on those charges, Counselor. Please tell me your name.
Yes, Your Honor. My name is James L. Thomas III.
21 CF 8162. Sir, you're here charged with possession of methamphetamine, possession of drug paraphernalia, and resisting an officer without violence. I'm going to appoint an attorney to represent you. There is probable cause in this case. I'll stay your bond at $1,000 on count 1, but I'll reduce counts 2 and 3 to $100 each. You can't possess or consume any controlled substance without a valid prescription. Do you understand?
I overstand. I just want to have one thing. I was stopped prior that night and they stopped
Hold
me
on, hold
again.
on. Let me tell you something. Before you say anything else,
Yes, ma'am.
I need to make sure that you understand that everything you say is being recorded and can be used against you later.
Yes, I was already stopped and they stopped me again. I seen the officers ahead of me. He ran towards me and slammed me off of my bike. I was on Kaylee, trying to cross over Kaylee. If I was trying to hide anything, I was already stopped. I'm headed up towards you. 3 vehicles. You leave out your vehicle, run towards me. Hey, come here, come here. It's in my affidavit. It's all here.
You wrote an affidavit?
No, the officer. It's nothing but the truth. I try to turn because there's cars coming. This is Kaylee. This is Kaylee Street. And he grabs me and slams me to the ground. I was already stopped tonight. The same night, I was already stopped, heading home. I don't know what, I'm afraid. Look what they're doing to us everywhere. I already been stopped that night. I was stopped once. You gonna stop me again? Come on now.
If you think you have some defenses, you want to talk to your attorney about it and have him raise that in front of the trial judge. The only thing we're doing here today is looking at probable cause and bond.
Yeah, ma'am. Yes,
But you may have some great defenses. So make sure you stay in touch with your attorney, okay?
yes, ma'am.
All right, good luck, sir. Please tell me your name.
Charles White.
21 CF 8147. You're here charged with grand theft of a motor vehicle. I'm going to appoint an attorney to represent you. There's probable cause in this case. Your bond will be $1,000. You can't have any contact with the victim or any witness in this case. Do you understand that?
Yeah.
All right. Please tell me your name.
Salvatore Michael Vecchio.
One of the alias names, Your Honor.
I don't have a court case number. All right. All right, sir, you're here charged with driving under the influence. There's probable cause in this case. I'll appoint an attorney to represent you.
Your Honor, he's been on Social Security income for 11 years. Would you consider a lower monetary bond than what is listed on the affidavit?
No. Your bond is $500. You can't possess or consume any alcoholic beverages. Do you understand that?
I don't drink.
You also can't possess or consume any controlled substance without a valid prescription.
I got
And you-
valid prescriptions.
All right, and you can't drive without a valid Florida license. Do you understand?
Yes, ma'am.
All right, good luck, sir.
Don't plead right now?
No, you can't enter a plea today. Please tell me your name.
Alberto Matos Jr.
All right, you're here charged with driving under the influence and refusal to submit to a lawful test in 21 CT 4906 and 4907. There is probable cause for both of those charges. I'll appoint an attorney to represent you. Your bond will be $1,000 on each charge. You can't possess or consume any controlled substance without a valid prescription or any alcoholic beverages. Do you understand?
Yes, ma'am.
You also can't drive without a valid Florida driver's license. At this time, I'm revoking both of your out on bond cases, 20 CT 7702 and 20 CT 7701. That's it.
Your Honor, Samantha Snow bonded.
Please tell me your name. Sir, you're here in 21 MM 4757, charged with possession of drug paraphernalia. There's probable cause. Did the state have an offer?
No, Your Honor.
Your Honor, we'd like to plead to the bench if this court would consider a plea of withhold with credit time served on the possession of drug paraphernalia.
I will not.
May I ask the reasoning, Your Honor?
He has an extensive criminal history, so I'm not inclined to withhold on that.
Just a moment, Your Honor. Your Honor, would you consider release on own recognizance as to the charge as possession of drug paraphernalia? He does have an address with his mother to receive mail.
Does the state have any objection?
State would ask for a pretrial release, Your Honor.
I don't think he's going to qualify for that.
He does not, Your Honor.
May I also ask the court to set a court date so I can even send him with his next court date?
All right, I'm going to release you on your own recognizance, but you understand that you can't possess or consume any controlled substance without a valid prescription? You have to answer out loud.
Yes, Your Honor.
And we're going to give you a court date, and you understand that if you don't come back to court, that judge can issue a warrant for your arrest and could hold you at no bond.
Yes, Your Honor.
All right. We're going to get you a court date. Okay, just a minute.
July 29th at 7:30. Division 80,
That's Evelyn Jewett.
courtroom 9C.
All right, you heard that. You have to answer out loud. All right, so you're going to be there, right?
Your Honor.
Good luck, sir.
Thank you.
Please tell me your name. 21 MM 4765. You're here charged with trespass on property after warning and resisting an officer without violence. There is probable cause. Did the state have an offer in this case?
Not at this time, Your Honor.
All right.
Just a moment, Your Honor. I did have a chance to speak with Mr. Haynes in the back. I believe we would like to plead to the bench as to trespass and resisting a pretty limited criminal history, Your Honor. There are no multiple trespasses or multiple resisting officers without violence. Would you consider withhold of adjudication on both those counts as well as the credit time served?
I would. Mr. Haynes, please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
So help me God.
All right, you heard what Mr. Branch just said. Is that what you want to do here today?
Yes, ma'am.
You had an opportunity to discuss with him the rights you'll be giving up if you enter a plea of guilty or no contest.
Yes, ma'am.
Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
You understand that you're giving up your right to remain silent and your right to a jury trial.
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
You understand if you're on probation anywhere, this plea can violate that.
Yes, ma'am.
And if you're not a U.S. citizen, you can be deported.
Yes, ma'am.
Has anyone threatened you or promised you anything to get you to enter this plea?
No, ma'am.
At this time, how do you wish to plead to the charges of trespass on property after a warning and resisting without violence?
No contest.
I'll accept your pleas. I find them freely and voluntarily made. How old are you?
19 years old, ma'am.
So this petty theft from a couple months ago, you were an adult.
Yes, ma'am. It was supposed to be, I was supposed to go to court. I went to court 3 times, and then the last time, I guess, that I took responsibility for that, and the judge issued a warrant for my arrest. I totally forgot that was on me, but I'm getting expunged because I was supposed to be going to the Marines after college. So, and then this thing, I'm gonna handle it separately, but
Where are you in school?
UCF,
What year are you?
2nd year.
Do you live in a group home?
No, ma'am. I am a foster kid, but I live on PEST, which is, like, if I go to college, I get $12.56 a month from the state.
All right, so help me understand this, Mr. Haynes, because now you're an adult. You have very little crime in your history, and it sounds like you're set up for a pretty decent future. Why are you at the Knights Pub?
Because I am a party promoter as well. So on the weekends, when I do that, I promote parties, house parties, and I get paid.
At 19,
Yes, ma'am.
because you can't drink.
No, it's just party promotion. So like I throw like, so I don't know if you guys heard of like different house
I know what
parties
it
and-
is, but it means that you're at parties where everyone else is drinking. So
Well-
you're promoting parties where they're drinking.
Yes, ma'am.
You're 19.
I'm working the event though, so it's kind of like,
You have a job.
yeah, 2 jobs actually. I work at Taco Bell, crew trainer, and then I work at Zaxby's, crew trainer as well.
All right, Mr. Haynes, I don't want to see you again.
Yes, ma'am.
You have, it sounds like a really promising future. Don't come back here.
Yes, ma'am.
I'm going to withhold adjudication. I'll give you credit for the 2 days that you've been in custody. 2?
1.5.
Is it 1?
Yeah, 1.
Well, it might count as 2. Counts as 2. I have to order that you pay court costs. It's about $300. How long do you need to pay that?
2 months, because I have to worry about paying my rent. That rent.
Well, you have to worry about a lot. So I'm not trying to set you up for failure.
No.
I'll give you 3, I'll give you 4. I want it out from under, I want you out from under it.
How many?
Your Honor, if I may, would you be open to just a year as?
I think that if I do that, it may never get paid, and then it's gonna be a lien, and then that's gonna affect everything for him.
6 months.
All right, I'll give you 6 months to pay it. You gotta pay it, you understand?
Yes, ma'am.
All right, good luck. You have 30 days to appeal in writing.
Thank you so much.
Don't come back.
Spoke with Mr. Haynes as a friend of the court, Your Honor.
He's what?
I spoke with Mr. Haynes as a friend of the court.
Yes, I didn't appoint your office.
Thank you, Your Honor.
Yes. Sir, please tell me your name.
Manuel Rodriguez.
21 4763. You're here charged with open carrying of a weapon. There is probable cause.
Your Honor, I spoke with Mr. Rodriguez about that charge, and I believe nowhere in the affidavit did it say he didn't have a license, and I believe he does have a license. Would you consider ROR on that charge pending that evidence being entered or brought before the court?
What says the state?
With regards to a license, is the license referring to a concealed weapons license?
I think that's what he's talking about, and this is an open carry
This is
charge.
an open carry case, Your Honor, so I don't know how that would be relevant. You know, the state of Florida does issue licenses so that people can lawfully conceal carry weapons, but in this case, the facts allege that the firearm was taken from an unconcealed place, from a concealed place to an unconcealed place out in the open, where it was observed by an officer, Your Honor. So I don't know exactly how whether or not the defendant had been issued a license to conceal a weapon would be at all relevant to the crime as charged.
The gun may have slipped from the location. I spoke with Mr. Rodriguez. He was laying on the ground, so there may have been the gun slipping to different locations, but he has assured me he does have a license as to, at least to conceal it. I don't know if the license allows him to open carry, but pending the presentation of that license to the court, I would still request ROR on this charge.
I don't see, he has hardly any criminal history, no FTAs. I'm going to release him on his own recognizance. Sir, you can't possess or consume alcohol. Do you understand that?
Yes, ma'am.
May I also request a court date for Mr. Rodriguez as well?
Yes, he'll get one.
Even if your attorney's, even if you're
Right. My name.
Hold on.
It's July 27th at 7:30. Courtroom 4A.
All right, good luck, sir.
Thank you very much, Your Honor.
Stay in touch with your attorney.
Okay.
Your Honor, Lisa Tar bonded.
Okay. Please tell me your name, sir.
My name is Prescott Kate Chomba.
You have a warrant out of Hillsborough County for false verification of information to a pawnbroker. The bond is $2,000 on that charge, and we'll notify them that you're here so they can transport you, but you do have a bond. Do you understand?
Yes, ma'am.
You understand?
Yes, I do.
Okay, good luck, sir. Please tell me your name.
Ricardo Collins.
Thank you. You have a warrant out of Seminole County in 19 MM 251 for failing to appear on a charge of possession of less than 20 grams of cannabis. There is no bond on that warrant. We'll notify them that you're here, and I'll appoint an attorney to represent you. Good luck, sir. I have Gabriel Martinez. We don't have Gabriel Martinez?
No, Your Honor.
Okay.
Is there a reason, Your Honor?
Do you have a booking number for him, Your Honor?
21016332.
They bonded.
I see. All right, ma'am, tell me your name again.
Ashton Christopher.
This is 21 CF 8171, the argument as to the burglary. It says in the very first paragraph, a female complainant, later identified as Shakira Ward, stated that she and her children were locked inside an apartment due to an altercation. So then I think that the burglary as alleged in this affidavit is into the part of the apartment where she was not allowed to be. So do you have any argument as to that? Do you want a moment to find some case law to see if that doesn't, if there's anything that gives us some indication of whether that is or is not a burglary?
No, Your Honor, but if you do find probable cause, I have a secondary argument as to holding her.
Well, because it's a punishable by life.
Yes, Your Honor. And do you find probable cause on the charge, Your Honor?
I think there is, unless there's anything you can tell me that says,
Allow me a few seconds, Your Honor.
Okay.
Because you're asking, I will, just a moment.
I understood that to be the burglary. So that's where I think the probable cause stems. But if you have some case law that says because she was licensed to be in a part of the apartment, she can be in all of it, that would affect my ruling.
Yes, Your Honor, just a moment, please.
And if the state can find anything useful, let me know.
Your Honor, I can't find any case law that would go to that particular set of facts.
All right, hold on, I'm going to read this again. I'm reading the statute right now. What says the state?
Your Honor, if I may, there is some case law about places open to the public and then rooms within those establishments being cut off from the public.
Right.
Your Honor, I mean, this is a private residence. The owner of the residence, or the occupant of the residence had asked the defendant to leave or disinvited. So an invitation, just like you can invite somebody, you can disinvite somebody from your home. And once there was once the invitation had been revoked, further trespass into the premises, with regards to the statute, the state would argue that there is PC for count one, pursuant to the affidavit submitted to this court.
So I'm thinking back to your arguments earlier, Mr. Brands. I think it's clear from the affidavit that she was initially licensed to be in the apartment. I don't see anything about parts of the apartment where she was not licensed to be until it's the 1, 2, 3, like the third full paragraph. It says, Ward stated, while she was in the bedroom retrieving her children, she heard the defendant yelling, "You got this hoe here." She then saw the defendant grab mace from inside her shirt. Williams feared she was going to spray her and her children, so Williams closed the bedroom door and locked it. The argument he made earlier is that the license was revoked after the assault, right, Mr. Brands?
On Williams, yes, Your Honor.
Right.
And because all of these incidents were happening simultaneously, and Ms. Ward, in her statement, stated she closed the door. Williams closed the bedroom door and locked it to protect her and her children. Williams told the children to go into the bathroom, which was located inside of the bedroom, and instructed them to lock the door. Ward didn't go on to say that Ms. Fair-Conature busted the door. That doesn't come until later with Williams's testimony.
Mm-hmm. So I suppose the argument would be a closed and possibly locked door is revoking the license to enter, and then your client entered?
But, yes, but as, I know this is probably all arguments to make at trial, but because because the license was rescinded and the battery, at least in my reading of the affidavit, all took place at the same time, how is a defendant to know, okay, here's the point where I'm not allowed to be here, and now I know, or I intend to commit a crime of burglary?
Well, I think the closed door is you're not allowed in here. So to quote, bust into a closed door, it's pretty clear you're not supposed to be in that area. But
My greater fear is the holding at no bond as to this charge, as it's a punishable by life charge, and as the facts as we've discussed, the sequence of events.
can I have the attorney's approach?
Yes, Your Honor.
All right, here's what we're gonna do, ma'am. Well, let me have the state request on record.
Your Honor, in this case, the state would request, I believe it was count one, that was, there was a PC challenge, so the state would request 24 hours to correct any PC issues in this case.
I'll grant that request, so we'll see you tomorrow, ma'am. Yes. Because if she bonds out us to the rest, it's not in her best interest. And she has bond out. She's at no bond right now. She didn't.